Welcome to the Virtual Center for the Study of the Constitution and Civic Responsibility, an ongoing inquiry into American political origins and evolving institutions. The Executive Director of the Virtual Center is Dr. Bill O'Brien. He's also your host for this continuing conversation. Here he is now, Dr. Bill O'Brien.
Thank you, Bob Kincaid, and welcome to a Tuesday edition of the Virtual Center for the Study of the Constitution and Civic Responsibility. Today is Tuesday. It is the 12th day of January in the year 2016, and we're in the midst of a snowstorm here in Appalachia, southern Appalachia, and schools are all letting out early, and it was interesting. I went to the Rotary meeting at 11:30, and the sun was shining, and I came out and it was pouring down snow. And we supposedly have one of those clippers coming through this afternoon, and it's going to drop probably two or three inches on the ground, but it's all sticking. Everything that hits the ground is sticking because the temperatures have been so cold the last few days. And so I guess our extended fall is definitely over. And I hope that you're enjoying the weather wherever you are. I guess we can't do much about it. But I hope, again, if you are in weather which needs some attention, I do trust and I urge you to be careful. Here it's pretty slick outside. It's just begun, but already it's pretty slick because everything is laying on. None of it's melting. Anyway, welcome to our program today here at the Virtual Center. It's a pleasure to be with you today. On this Tuesday. Today, of course, is our abbreviated programs. We begin at 1:30 p.m. East, and we'll finish at our regular time. So our program will be an abbreviated 90-minute program today. But hopefully on Tuesdays, we can usually make it without stopping for a break. So perhaps we can get quite a bit in. I'd like to see if we can complete Justice Stevens's dissenting opinion in the Heller case today. I'd like to, complete the issue of gun regulation with the State of the Union message being delivered this evening, the president's last one. A number of us at the Rotary meeting today were talking about, what the president might say. We have a very interesting situation. This is just a happenstance, but one of the female members of our club, wonderful lady, is a storyteller, and she, has appeared in a number of places around the country, telling stories, tall tales, as it were. And so she has a reputation in the club, and usually 3 or 4 times a year, there'll be one of our programs. Will at least half of it will be Sue telling us one of her stories, and they're just delightful. So she was sitting at our table today, and one of the fellows asked her if she had been telling any stories recently, and she said, no, not since November. And she said, you got to be careful when you get into November because Christmas is coming, and if you get caught lying, Santa Claus won't come. And so one of the other folks at the table mentioned that we really didn't need any tall tales this week because the State of the Union message is tonight, our governor's message is tomorrow night, and the Republican debate is on Thursday night. So basically, his whole point was, we'll have our fill of tales this week, Sue, so you can have the week off. Was basically the message. Seriously, before I want to give you the phone number and various things as I usually do, but, I just wanted to share with you that our program in Rotary today was delivered by a good friend, Matt Stanley, who's the president of our local water company here, the Beckley Water Company, and he pointed out that there's only about a dozen independently owned water companies in the United States, that most of them have been bought by the big international conglomerates, American Water, and of course American Water, as we know, is housed or based in Germany, and most of the water companies have been bought up by these conglomerates. And his whole presentation was about how dire the situation in the not only this nation but the world is in relation to water. And he had some really interesting data. And as he said, what makes water an interesting topic in a presentation like this is that nobody ever even thinks about it. You just turn on the spigot and you assume that it's there. And the fact of the matter is, in a lot of places throughout the world, it isn't there. And he was talking about the Southwest and how the southwestern part of this country is drying up. And he said, if you go out into, where the football game was played last night in the Phoenix, Tempe area, it's drying up there. And his prediction is that in less than 100 years, the flow is going to totally turn, where people are relocating out there for the climate. Within the next 50 to 70 years, people are going to be coming this way because the area is going to dry up. And he was mentioning as an example the Rio Grande, and he said there is no Rio Grande out there anymore. It is pretty much totally dried up. So pretty frightening in a lot of ways. And he was talking about the infrastructure just locally and how all the infrastructure needs to be replaced. Most of it, not just here but all over the country, was built in the 20s and 30s. And he said that they here locally. They do about 300 leaks a year. And they're coming more and more all the time. And part of it is because of the mountain terrain that we have here and the varying temperatures, the extreme cold, and sometimes the heat as well. And the result is that these old pipes, these old systems leak. And so we're confronted with that. And his whole point is that, as you look forward, there's no way we can not see our water rates go up. And as companies like utilities, like water companies, for example, move to try to become more proactive rather than reactive and begin to replace some of this infrastructure that is in such dire need. And one of the things that we were talking about was our governor is giving the State of the State message here in West Virginia tomorrow evening. And we were speculating as to what he might say or what he could say. West Virginia's economy is absolutely in shambles. Just yesterday, Arch Coal filed for bankruptcy. That's the third major coal company to file for bankruptcy in the last 6 months or so. And there's 146 jobs that go with that announcement. And the state deficit, we're looking at a deficit in the area of $353 million, with predictions that next year it's going to be even worse. And because of the lack of planning and foresight by our political leaders over the years, nobody has really done anything to prepare for this transition from coal into whatever. There is no whatever. So, in essence, we were speculating as to what the governor is liable to say tomorrow in his presentation. Anyway, it's pretty bad the economic outlook here in the mountains, and that was on my mind, so I did want to at least open with that, kind of get it off my mind, so we can get back into Justice Stevens' dissent in the Heller decision and give that issue the attention that it's worth. As you know, we have a phone number, and through the use of that number, you can pick up the phone and get on the air and share your thoughts or your ideas, your suggestions, concerns, whatever. And we would love to hear from you. Our phone number is area code 304-663-4676. That's 304-663 HORN, HORN, 4676. And if you are a little bit reluctant to get on the air and you want to share your ideas with me one-on-one via an email, I'd love to hear from you. And I'll reserve the right, if your point is one that I think our other listeners can benefit from, and chances are it probably will be, I'd like to reserve the the right to get it on the air. And if you don't want your name, just your first name mentioned, then by all means, just give me an artificial name and it'll be fine. My email address is waobrien906@gmail.com. That's waobrien, OBRIEN, 906@gmail.com. And finally, I want to apprise you of the fact that for the last 3 or 4 months, we have had a page devoted to the Virtual Center on Facebook. And if you go to Facebook and you type in the Virtual Center for the Study of the Constitution, you will be into our Facebook page, and there are a number of postings there. I put most of them there. I would really enjoy your reactions to some of those pieces. The situations that we've been dealing with over the last week or so about gun regulation and the research being done by Saul Cornell, as revealed in his article in The Atlantic on the 17th of December, has been the focus of our programs. And I think what it speaks to, and several members of the Rotary Club here in Beckley were commenting on this morning. I had a piece on this, the Saul Cornell research, principally, in this morning's local newspaper, and a number of the members of the club had read it, and they were commenting on it. And obviously, given the fact that we are in West Virginia, there's a lot of support, a lot of support for gun ownership, and a lot of concern about regulation and all the other things that go with it. And so I know that, and many of the people that were commenting, I know are hunters and gun owners and have always been that. But the points that they made, and I was so appreciative of this, and they said, Bill, that doesn't matter. It doesn't matter whether we agree with what you said or disagree with what you said. The major point was that there's a lot of information in there, and the issue needs to be talked about. And a couple of folks commented that that's the problem in Washington now. There's so much bitterness and distrust that nobody's talking, and therefore nothing's getting done. And areas where there could be action taken and compromises reached are not even being addressed. And so that's what many of these people argued, that they appreciated the information because it was information that most of them didn't know. And it needs to be weighed and considered and reflected upon in light of the other information that has been discussed and written about frequently. And in the course of that happening, we might be able to make a little bit of progress here and there and on many of these controversial issues. So I have to tell you that I was quite appreciative of the reaction to the piece. And because, in fact, when you put, when you go into the media with an issue, especially an issue in a place like West Virginia, as topical and as hot as gun ownership, you can begin to expect that you're going to get some heavy reaction from one side or the other. And at least to this point, most of the reaction that I've gotten has been extremely positive, and that's what I intended and I hoped for. So again, with that, I'd like to begin to go back to the issue of the Heller decision. And again, we refer to the Heller decision because that's what everybody calls it. It's important to recognize that the title of the case is District of Columbia versus Heller. Heller is not the complainant. Heller is the object of the suit filed, the appeal filed before the Supreme Court by the District of Columbia, because the Court of Appeals had struck down the district's gun regulation of handguns. As you recall, and we looked at this yesterday when we considered Justice Scalia's opinion in the case, the majority opinion. The case made its way through. Heller was a police officer who was licensed to carry a weapon on the job, and he applied for permit to have a handgun for his own defense in his home. And because that request violated the law, which denied the ownership of handguns in homes, it was denied. And then on appeal, the law was struck down by the Court of Appeals. And it was in reaction to that the District of Columbia took the case to the Supreme Court. And it was heard in 2007. And we know the reaction and we know the result of the case. The Supreme Court, this was really our program yesterday for the most part. The Supreme Court, in the majority opinion written by Justice Scalia, established the firm principle that the right to bear arms under the Second Amendment gives all citizens in this nation the right to own a weapon. And struck down the handgun law, the handgun ban in the District of Columbia. And we know that since that time, there has been so much debate and so much back and forth about this particular issue that it seems to be so timely that it would be, I think, a disgrace to have this material in our hands and not spend time here at the Virtual Center on considering this issue. What we talked about yesterday in the Scalia opinion what I talked about were some of my observations about the particular opinion in this case. It seems to me that there's little doubt that this is an opinion that the conservative majority on the court, the 5 justices who found for Heller and against the District of Columbia in this case, were making a decision that they wanted to make. And the reason I say that, and the reason I put the label of judicial activism on it, is because, in effect, the majority in the court in this case, I believe, as I read the decision and read the opinion explaining the decision, rationalizing it, is that this is a situation or is a decision that the majority wanted to reach. It was not a situation where evidence was collected and the decision was based on the evidence. On the contrary, it seems to me pretty clear as you read this opinion that this was a decision that the majority wanted to reach, and the evidence collected and presented in Scalia's opinion is an effort to rationalize that particular decision. In other words, and I think I put it this way yesterday, and it seems to at least make sense to me, I hope it does to you as well. Whereas one would expect that the evidence led to the decision, in this case, it's pretty clear that the decision drove the evidence. In other words, the presentation of evidence is presented in a way which justifies and rationalizes the decision that the majority wanted to make. And one clear example of that, we talked several of these yesterday, but one clear example of that is the fact that Justice Scalia's opinion chooses to take the second part of the Second Amendment, the part about the right of the people to keep and bear arms shall not be infringed. That's the second clause of the Second Amendment. The first clause, as you know, relates to the issue of a well-regulated militia. And the majority opinion chooses to take the second clause and deal with it first. In other words, take take the second half of the Second Amendment and address it first. By definition, then, that tends to relegate the first clause of the Second Amendment to secondary status. In other words, as the amendment is written now, as the founders wrote the amendment, the well-regulated militia issue comes first. The right to bear arms comes second, theoretically, as a support for the first. What Justice Scalia does, in his opinion, is totally reverse that process and takes the bearing arms clause first. And then well into the decision, close to midway in the decision, in the opinion, the opinion takes the second, the well-regulated militia clause into consideration and relates it to the explanation of the bear arms portion of the Second Amendment that the court majority offers in defense of its decision to strike down. What the decision is to reverse the appeals court the decision. Excuse me. So I hope that I didn't confuse you, but I don't want to go back necessarily through the Scalia material again today. We covered quite a bit of it yesterday. I will remind you, however, that Justice Scalia's opinion suggests, and I find this particularly influential and significant in this decision, that the majority it takes as its first issue the phrase, the rights of the people, the right of the people to bear arms, to keep and bear arms. And basically, he focuses on the meaning of the word people. Obviously, his intent, his goal, is to suggest that in considering people, one must consider each individual independently that makes up the totality of the people. And what he does to make his case is look at other amendments in the Bill of Rights where the people are mentioned. And because every one of those suggests that while the term people is used, the clear meaning is each individual which makes up the people in toto. What Justice Scalia argues then is that one must take the use of the term right of the people in the Second Amendment and treat it the same way as it's treated in other amendments. In essence, then, what he's suggesting is the right of the people to keep and bear arms means every individual in the country that comprises the totality of the people. In other words, the right to bear arms is an individual right. And it therefore is a right that not only applies to a chosen subcategory of people, which is those serving in militia, but by relating it to all individuals in the country and suggesting that it's an individual right to keep and bear arms, then Justice Scalia is able to move expeditiously to the decision that he wants to make. I think that if you look at the evidence and read the opinion this way, you can begin to see how the majority opinion is organized, is structured in order to reach the particular decision that the majority wanted to reach. With that, I think we're at the point where we ought to begin to consider seriously the dissenting opinion in this particular case, written by Justice John Paul Stevens. And of course, the minority of 4 justices besides Stevens consists of Justice Souter, Justice Ginsburg, and Justice Breyer. They joined in the consent at that time. And of course, we know that there are new members on the Supreme Court now that were not members at that time. Justice Sotomayor and Justice Kagan as examples. I want to begin looking at Justice Stevens' dissenting opinion in the Heller case by returning to a paragraph in that dissenting opinion that we looked at yesterday. And the reason is because in it, Justice Stevens is pretty well expressing his opinion on the court's decision, on the majority opinion. And I think it's pretty telling. This is what Justice Stevens says it's about the 5th paragraph in the dissenting opinion. And it reads as follows. The opinion of the court, and of course what that means is the majority opinion written by Justice Scalia. The opinion of the court announces today, the opinion the court announces today fails to identify any new evidence supporting the view that the amendment was intended to limit the power of Congress to regulate civilian use of weapons. Unable to point to any such evidence, the court stakes its holding on a strained and unpersuasive reading of the amendment's text. Significantly different provisions in the 1689 English Bill of Rights and in various 19th century state constitutions, post-enactment commentary that was available to the court when the court decided its case in Miller, and ultimately a feeble attempt to distinguish Miller that places more emphasis on the court's decisional process than on the reasoning in the opinion itself. The way I translate that, Justice Stevens is accusing the majority in this case of making law, of reaching a decision that it wanted to reach, even though the evidence to support that decision is not there. And what they have to do, because no new evidence has surfaced since the court reached its decision in Miller, which basically suggests, in the Miller decision, the court said that there is no evidence, nothing new to indicate that the Second Amendment was intended to support or enable individual citizens to own firearms. That right, the court said in Miller, is not supported by any evidence. That was the court's decision. Consequently, the Heller decision overturns that. It overturns Miller, and as Justice Stevens says, it overturns Miller without any evidence. That instead, what the court majority engages in is what Justice Stevens referred to as a strained and unpersuasive reading of the amendment's text. And that's just the point that I was making in my comments earlier. By taking the second half of the Second Amendment and addressing it first, the court is setting up its case, its decision. But on the other hand, there's no reason to do that unless it is to reach a particular decision. And that, I would suggest, is what Justice Stevens says in this paragraph. He said, ultimately, the court's majority opinion is a feeble attempt to distinguish Miller that places more emphasis on the court's decisional process than on the reasoning in the opinion itself. In other words, there's more information available in this opinion on the decision the court wanted to reach than there is in the rationale or the reasoning that is given to support it. Yesterday, we looked at the beginnings of the Stevens decision, and I want to share with you one paragraph that we looked at yesterday from a 1934 law passed by Congress called the National Firearms Act. And Justice Stevens says, in 1934, Congress enacted the National Firearms Act, which was the first major federal firearms law, first time that the federal government took on the issue of firearms. And this case, the Miller case, reached the court. And in that decision, this court held, and this is a paragraph or a quote from the Miller decision, in the absence of any evidence tending to show that possession or use of a shotgun having a barrel of less than 18 inches in length at this time has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. In other words, the court in Miller, based on a 1934 law passed by Congress, is saying that there's no evidence to support the idea that the Second Amendment was ever intended to give individuals the right to bear weapon, have a firearm. Justice Stevens goes on. The view of the Second Amendment we took in Miller, that it protects the right to keep and bear arms for certain military purposes, but that it does not curtail the legislature's power to regulate the non-military use and ownership of weapons, is both the most natural reading of the amendment's text and the interpretation most faithful to the history of its adoption. In Miller, then, the court had pretty clearly established the principle that the Second Amendment did not consider or grant individuals the right to bear arms. This particular opinion in Heller reverses that decision, reverses the court, and as Justice Stevens says, does so with no new evidence. That instead, what the court engages in is what he calls a strained and unpersuasive reading of the text and a reading of history which supports it. In his dissent, Justice Stevens begins his consideration of the Second Amendment at the beginning of the Second Amendment. In other words, he takes up the first clause first. And of course, the most obvious reason for that is because it comes first. So I think right away, we see a difference. And the fact that the dissenting opinion written by Stevens takes up the first clause first seems to me to indicate the significance of Justice Scalia's decision to take up the second clause first. That suggests an agenda or a goal or a decision that's already been made. So under the well-regulated militia, Justice Stevens says the following. The preamble to the Second Amendment makes three important points, and the preamble, of course, is the first clause. Makes three important points, and here it is. A well-regulated militia being necessary to the security of a free state. That's the first clause. This, Justice Stevens refers to as the Second Amendment's preamble. He said it contains three important points. It identifies the preservation of the militia as the amendment's principal purpose. The reason the militia clause comes first, Stevens is saying, is because the militia issue was the one that needed to be addressed first to the founders. If the right to bear arms was the principal intent of the Second Amendment, it would have come first. At least that's the reasoning that Stevens seems to be placing on it. So the first point that this particular clause makes is that it identifies the preservation of the militia as the Second Amendment's purpose. Second, it explains that the militia is necessary to the security of a free state. And third, it recognizes that the militia must be well regulated. In all three respects, it is comparable, Justice Stevens says, with state declarations of rights that were adopted at the time of the Declaration of Independence, 1776. Remember, that's 11 years before the Constitution. But you'll recall that when the Declaration of Independence was ratified by the Continental Congress, in June 7th, 1776, was when Congress voted for independence. At that point, Congress then urged individual colonies which were no longer colonies, they were now states. Congress urged these states to write constitutions because they were now independent states rather than colonies of the mother country. And at that time, Stevens says, these state declarations of rights, written at approximately the same time as the Declaration of Independence, these state provisions highlight the importance that members of the founding generation attached to the maintenance of state militias. They also underscore the profound fear shared by many in that era of the dangers posed by standing armies. While the need for state militias has not been a matter of significant public interest for almost 2 centuries, Stevens says, that fact should not obscure the contemporary concerns that animated the framers. What Stevens is pointing out is indeed validated by the sources, by the evidence. If you read the state constitutions that were adopted in and around the Declaration of Independence, it's very clear that the fear of a standing army was paramount. The British troops occupying Boston was what they feared most. That's traditionally what standing armies historically had always been used for, is brutality and the abuse of their own citizens. So consequently, when these states wrote their own constitutions, they were quite determined to put a premium on the militia, on the importance of the militia, and the importance of the militia being controlled by the state. And then Justice Stevens gives some specific examples. And it's these examples that I think we must take into consideration. His dissenting opinion reads as follows. The parallels between the Second Amendment and these state declarations and the Second Amendment's omission of any statement of purpose related to the right to use firearms for hunting or personal self-defense is especially striking in light of the fact that the Declaration of Rights of Pennsylvania and Vermont did expressly protect such civilian uses at the time. Article 13 of Pennsylvania's 1776 Declaration of Rights announced that, quote, the people have a right to bear arms for the defense of themselves and the state, unquote. It went on, the Pennsylvania Declaration went on to assure that the inhabitants of this state shall have the liberty to fowl and hunt in seasonable times on the lands they hold, and on all other lands therein not enclosed. Vermont's Declaration of Rights, adopted in 1777, guaranteed, quote, that the people have a right to bear arms for the defense of themselves and the state. The contrast between these two declarations and the Second Amendment reinforces the clear statement of purpose announced in the amendment's preamble. It confirms that the framers' single-minded focus in crafting the constitutional guarantee to keep and bear arms was on military uses of firearms, which they viewed in the context of service in state militias. So says Justice Stevens. This is legal language, and sometimes it's a little bit difficult because it seems to go around and around. So let me see if I can put that into words that we can get our arms around and understand. What Justice Stevens is saying is that in the state constitutions drafted and adopted at the time of the Declaration of Independence, specific states put in clauses in their Declaration of Rights guaranteeing citizens the right to bear arms for their own protection and for the right to hunt. It's in Pennsylvania's Declaration of Rights. It's in Vermont's Declaration of Rights. It's not in the Second Amendment to the Constitution. So Stevens's logic is, if it was clearly written into state constitutions, then when the Second Amendment was drafted by the committee chaired by James Madison, Madison knew that there was an option, and that several states had taken the option to put in their specific language in their state constitutions protecting citizens' rights to bear arms. In drafting the Second Amendment, Stevens is reasoning, Madison could have put it in because it was in a lot of other places, and he didn't. Not only that, but he began the Second Amendment with the well-regulated militia clause. And what Stevens is saying is, if you contrast what's in the state constitutions and what's in the Second Amendment, it's pretty obvious that Madison's decision to not put the right to bear arms first as the principal objective of the Second Amendment becomes significant. So that's the reasoning that Justice Stevens is taking here. Since it existed, and since Madison could have used it if he wanted to, then it really strains logic to try to go back now, 250 years later, and suggest that that was Madison's principal intent, when he had draft copies of exactly that language in state constitutions right in front of him, and he chose not to include them. So it seems to Justice Stevens and the minority that Madison's intent in the Second Amendment is pretty clear by what it doesn't say. It doesn't say what Justice Scalia and conservative interests today wanted to say. And again, we have to recognize that by a 5-4 majority, the Supreme Court has ruled that it did say that. That's what makes this decision, it seems to me, so very significant. The conclusion, then, that Justice Stevens reaches on this issue is as follows. The preamble, the first clause, thus both sets forth the object of the amendment and informs the meaning of the remainder of its text. Such text should not be treated as mere surplusage, for it cannot be presumed that any clause in the Constitution is intended to be without effect, unquote. And that's a quote from Marbury versus Madison, the Supreme Court, John Marshall, in 1803. Marshall said in Marbury versus Madison, it cannot be presumed that any clause in the Constitution is intended to be without effect. Translated, what Marshall is saying is everything that's in the Constitution is in it for a reason. Things aren't just thrown in there because they look good. So the fact that the preamble to the Second Amendment, the first clause, sets forth the object of the amendment and informs the meaning of the remainder of its text, you can't treat that first clause like it was just excess baggage and didn't need to be there and is not important. John Marshall made the point that every clause in the Constitution is important or it wouldn't be there. So then, in his opinion, his dissenting opinion, Justice Stevens draws this conclusion about the well-regulated militia, the preamble to the Second Amendment. The court today, he says, tries to denigrate the importance of this clause of the amendment by beginning its analysis with the amendment's operative provision and returning to the preamble merely, quote, to ensure that our reading of the operative clause is consistent with the announced purpose, unquote. That's not how this court ordinarily reads such texts, Stevens says. And it is not how the preamble would have been viewed at the time that the amendment was adopted. While the court makes the novel suggestion that it need only find some logical connection between the preamble and the operative provision, it does acknowledge that a prefatory clause may resolve an ambiguity in the text. Without identifying any language in the text that even mentions civilian uses of firearms, the court proceeds to find its preferred reading in what is at best an ambiguous text, and then concludes that its reading is not foreclosed by the preamble. In other words, what he is doing is taking Justice Scalia to task for Scalia's decision to address the right to bear arms first, because that's the emphasis he wants to be the Second Amendment. And he's taking Justice Scalia to task for that. And he said basically the only way that they can find what they want to find in the Second Amendment is by taking the second clause out of context, putting it first in its opinion, and then forcing the first clause of the Second Amendment to support it or relate to it. In other words, it, by definition, reduces the preamble, the first clause, to secondary status in the court's interpretation. And then Justice Stevens takes on the majority opinion's issue about the right of the people. This obviously is the first issue that Justice Scalia addresses, which says that it's critically important to the majority opinion. And this is what Justice Stevens says about that decision. Quote, "The centerpiece of the court's textual argument is its insistence that the words 'the people' as used in the Second Amendment must have the same meaning and protect the same class of individuals as when they are used in the First and Fourth Amendments. According to the court, in all three provisions, as well as the Constitution's preamble, Section 2 of Article 1, and the 10th Amendment, quote, the term unambiguously refers to all members of the political community, not an unspecified subset. But the court itself reads the Second Amendment to protect a subset significantly narrower than the class of persons protected by the First and the Fourth Amendments. When it finally drills down on the substantive meaning of the Second Amendment, the court limits the protected class to law-abiding, responsible citizens." So, in effect, what Stevens is doing here is taking issue with Justice Scalia's need to base the entire majority opinion, the centerpiece of the court's whole argument, is on the meaning of the people. He had to basically interpret the meaning of the people as all the people in order to distinguish it from only those related to in the militia. And so therefore, the only way that it could relate to all the people was if it referred to each individual that comprises the totality of the people. And so consequently, that's the direction that Justice Scalia found himself having to go in. And the only way he could do that is to compare the term people in the Second Amendment with its use in some of the other amendments. And because the other amendments referred to individual people, for example, in the First Amendment, the right to assemble, the right to freely assemble, which is part of the First Amendment, means each individual's right to assemble with other people that he or she wants to associate with. In other words, it's an individual right, even though the amendment says the people shall have the right freely to assemble. But it means each individual has that right. And so what Scalia does is focus on that particular meaning of the people and then force fit the meaning of the people in the Second Amendment to it. I'm into some heavy legal analysis here, and I'm not an attorney, and I apologize. I don't apologize for not being an attorney. I'm not really sure I would really want to be one. But the fact of the matter is, what I have found and continue to believe is that it's very important to understand how these people think. It's very important to understand how attorneys think, how lawyers think, as it were, how they are trained to think. Because only then can you basically understand their logic and understand how they reach the points that they finally are able to reach. Later in the dissenting opinion, Justice Stevens returns to this issue of the words "the people," and he says, similarly, the words "the people" in the Second Amendment refers back to the object announced in the amendment's preamble. They remind us that it is the collective action of individuals having a duty to serve in the militia that the text directly protects. And perhaps more importantly, that the ultimate purpose of the amendment was to protect the state's share of the divided sovereignty created by the Constitution. Again, he's pointing out that the major concerns about the Constitution were the preservation of the rights of the states. And if you take that fact from the struggle over ratification and you link it to the state constitution's emphasis on the importance of state militias and the danger of standing armies, then you can begin to see why the Second Amendment is written the way it is, to emphasize the state militias. And I think at this point, I think it's important to go on a little bit of a tangent here. It's related, and I think this is the appropriate place for it. And that is to remind all of us, to remind ourselves that Madison's writing of the Constitution and participation in the writing of the Federalist Papers, with Alexander Hamilton principally, was intended to ease public concerns about the Constitution and about the power seemingly being given to the national government under the Constitution. The whole purpose of the Federalist Papers was to reassure the people that what seemed to be an all-powerful central government under the Constitution really was not. And that meant that Hamilton and Madison both found themselves in positions in several places in the Federalist Papers where they seemingly had to be supporting states' rights. But it's very important that we consider the context of the whole effort. You can take a sentence or two, you can lift it out of one of the Federalist Papers and make Madison and or Hamilton look like strident states' writers because of what they say. It's important to understand why they are saying it. They are saying it to reassure people that the Constitution does not bode the danger to the states that many of the anti-federalists saw in the Constitution. So again, the overall intent of the Federalist Papers is political. Its goal is to sell the Constitution to the people by making sure that all the concerns about the power of the central government are addressed and, if possible, argued down or argued away, or at least rationalized and explained. So here, when it's important to note that when Justice Stevens, in his dissent, is pointing out Madison's phraseology in the Second Amendment, it's important to recognize that the emphasis on state militias explains the context of the Second Amendment and explains why Madison put it that way. It seems to me to be a real stretch to try to suggest that Madison in the Second Amendment really intended to protect the people's right to bear arms against the government. All people. When in fact the whole purpose of his political life at that time was to make the Constitution work, to get it ratified and to make it work. We must remember the thing that most frightened Madison with ratification of the Constitution was a second convention. The only reason that Madison supported a Bill of Rights at all was because he was afraid that the absence of a Bill of Rights would become such a powerful issue amongst the people that they would support the idea of a second convention. And Madison knew and believed that if a second convention ever met, that was the end of the Constitution. That was the end of everything that they had been able to agree on through the summer of 1787. It was in order to block the sentiment for a second convention that Madison shifted his position and began to advocate the need for a Bill of Rights. And the most interesting thing, and we looked in previous months at a number of these statements and speeches that Madison made, in which he was urging members of Congress to follow through on his promise of a Bill of Rights. Because his concern was that if we renege on that, then we're going to be confronted with a second convention. And if that ever happens, we might as well just fold it up and go home because it's all over. That was Madison's strategy. That was Madison's intent, to preserve the central government under the Constitution with as much power as he felt a republic literally could have and should have. We know that Hamilton's goals for the power of government, strong government, were even stronger than Madison's. It's clear that Hamilton came around to support the Constitution because that was about all that he could expect the people to approve. And that becomes the driving agenda of the Federalist Papers themselves, is to basically argue away the concerns that opponents of the Constitution are raising in the media. So the point is that while Justice Stevens is emphasizing the issue of state militias because they were prominent at the time, part of the reason they're in there, that Madison wants them in there, is to re-emphasize again the divided nature of the federal government, the division of power between the central government and the states. And so Madison takes every opportunity to be supporting state power. That's the whole idea of the state militia, I believe, from Madison's point of view. I think that needs to be considered as well. The historical context here is critical. And of course, that's what the court, when the court begins to review history like this, what the justices are doing is creating the kind of context which seems to make their particular positions make sense. That's what Justice Scalia did, and that's what Justice Stevens is doing in his dissent. And then Stevens takes on Justice Scalia's use of the other amendments in order to force fit the Second Amendment into the preconceived definition that he wants for the term the people. Justice Stevens says, as used in the Fourth Amendment, and of course, as we know, the Fourth Amendment protects citizens from unlawful searches and seizures, the sanctity of their own homes, etc., etc. As used in the Fourth Amendment, Stevens says, the people describes the class of persons protected from unreasonable searches and seizures by government officials. It is true that the Fourth Amendment describes a right that need not be exercised in any collective sense. In other words, he's conceding, he's making a concession there to the majority opinion, to Scalia. But that observation does not settle the meaning of the phrase the people when used in the Second Amendment. For as we have seen, the phrase means something quite different in the petition and assembly clauses of the First Amendment. So in other words, what Stevens is doing is going back into the text of the First Amendment and the Fourth Amendment as well. He says, although the abstract definition of the phrase the people could carry the same meaning in the Second Amendment as in the Fourth, the preamble of the Second Amendment suggests that the uses of the phrase in the First and Second Amendments are the same in referring to a collective activity. By way of contrast, Stevens says, the Fourth Amendment describes a right against governmental interference rather than an affirmative right to engage in protected conduct, and so refers to a right to protect a purely individual interest. As used in the Second Amendment, the words the people do not enlarge the right to keep and bear arms to encompass use of ownership of weapons outside the context of service in a well-regulated militia. So what Justice Stevens is doing here is refuting, is seeking to refute the reasoning or the logic of Scalia's majority opinion on his definition of his effort to define the people as a collection of individuals with individual rights. Now he comes to the issue of to keep and bear arms. And Stevens says, although the court's discussion of these words treats them as two phrases, as if they read to keep and to bear, they describe a unitary right to possess arms if needed for military purposes and to use them in conjunction with military activities. And then I find this really interesting. He uses a little bit of sarcasm himself, because Justice Scalia, every opinion he writes is just reeks of sarcasm. Every speech he delivers, I mean, the media loves to quote paragraphs from Scalia's speeches because he's so clever and so bright in his use of words. And the sarcasm that he uses is powerful. But it's interesting that Justice Stevens uses a little bit of that here as well. He said, in fact, he talks about this, and he says, the court appears to have fashioned its explanation about the right to possess and carry weapons in case of confrontation. The court appears to have fashioned it out of whole cloth. In other words, his whole point is they're making this, Justice Scalia has made up this whole thing, this idea of the Second Amendment relating to the idea, let me be specific here. The right to keep and bear arms means the right to possess and carry weapons in case of confrontation, which translates into the right to have a weapon in your home, rather than just for military purposes. And then Justice Stevens addresses the idea of bearing arms. So you got to keep arms, and then you have to bear arms. Justice Scalia wants to emphasize keep because people traditionally kept their weapons in their homes. Stevens is suggesting that history tells us that the idea of keep and bear arms generally go together and mean the same thing. They mean militia service. And as examples of that, he goes to the Oxford English Dictionary. And he says the term bear arms is a familiar idiom. When used unadorned by any additional words, its meaning is, quote, to serve as a soldier, do military service, fight. That's what the Oxford English Dictionary says. Bear arms means. It means to serve as a soldier, do military service, fight. Nothing in it, the definition, seems to suggest the right of every citizen to have an armed weapon in their homes. And here's the logic, and I even wrote in the margins that Justice Stevens here seems to be engaging in what I call, he makes a good case. And this is what Justice Stevens said. Had the founders wished to expand the meaning of the phrase bear arms to encompass civilian possession and use, they could have done so by the addition of phrases such as for the defense of themselves, as was done in the Pennsylvania and Vermont Declarations of Rights. The unmodified use of bare arms, by contrast, refers most naturally to a military purpose, as evidenced by its use in literally dozens of contemporary texts. I believe, I'm going to say this now because I think it's pretty obvious from what I have said so far. I believe, and I'm not an attorney, but I believe that Justice Stevens's dissenting opinion is much stronger than is Scalia's majority opinion. I think what makes Scalia's opinion stronger is the fact that it has a majority of the judges supporting it, 5-4. But I think the logic, the evidence brought to bear by Justice Stevens is much stronger for his interpretation of the Second Amendment than is Justice Scalia's. And his point, and this is the point that I made a little bit earlier, his point is that if Madison wanted to have the Second Amendment say that people have the right to keep and bear arms for the defense of themselves, he could have said that. That's what the Pennsylvania Constitution said. That's what the Vermont Constitution said. The fact that Madison chose not to include those explanations and a more definitive definition, Stevens believes, and so do I, to be very significant. Since he didn't use those phrases, that's not the meaning that he intended for the amendment to stand for. And this is, I think, very, very solid logic on Stevens's part. The court argues that a qualifying phrase that contradicts the word or phrase it modifies is unknown this side of the looking glass. And of course, that's reference to the Mad Hatter. Justice Scalia argues that a qualifying phrase that contradicts the word or phrase it modifies is unknown everywhere is unknown on this side of the looking glass. In other words, if that exists, it exists in Wonderland, in Alice's Wonderland, not here. But, Stevens says, this fundamentally fails to grasp the point. The standalone phrase, bear arms, most naturally conveys a military meaning unless the addition of a qualifying phrase signals that a different meaning is intended. When, as in this case, there is no such qualifier, the most natural meaning is the military one. And in the absence of any qualifier, it is all the more appropriate to look to the preamble to confirm the natural meaning of the text. Stevens's logic, Stevens's rationale is that in the absence of a qualifying phrase which defines more precisely what the meaning and the intent is, then one is left with what is written as it is written, without the qualifier. And that means that the preamble, which mentions the well-regulated militia, is the context for bearing arms, and that the two go together. Stevens says, and I know we're getting close to, it's about 45 minutes after the hour, so we've got about 12 minutes left in our program, so I'll try to wind this up because I'd like to finish it today. Maybe we can go back over it at the beginning of tomorrow's program and do a little bit of review, but I'd like to at least get through the analysis here. Stevens says, when each word of the text is given full effect, the amendment is most naturally read to secure to the people a right to use and possess arms in conjunction with service in a well-regulated militia, period. When each word in the text is given full effect, the amendment is most naturally read to secure to the people a right to use and possess arms in conjunction with service in a well-regulated militia. So far as appears, no more than that was contemplated by its drafters or is encompassed within its terms. Even if the meaning of the text were genuinely susceptible to more than one interpretation, the burden would remain on those advocating a departure from the purpose intended in the preamble and from settled law to come forward with persuasive new arguments or evidence. In other words, if you're not going to read the Second Amendment the way it's written, then the burden of proof is on those who want to read it another way to prove that it should be read another way. And his implication, of course, is that the majority opinion does not comply with that requirement. This is the part that I find particularly revealing and interesting, and I hope you do as well. And this will probably be the last major issue we'll deal with today, because we've gone beyond the 3/4 mark in our full hour. This is when Stevens goes back and quotes some of the founders themselves. This is his paragraph. This is a pretty powerful paragraph. Two themes relevant to our current interpretive task run through the debates on the original Constitution. So if we go back to the original debates on the Constitution at the Constitutional Convention, there are two themes which jump out at us as relevant to this debate about bearing arms and militia, well-regulated militia. And here's the first one. It's a quote. On the one hand, there was a widespread fear that a national standing army posed an intolerable threat to individual liberty and to the sovereignty of the separate states, unquote. So that's one of the issues. That was evident at the Constitutional Convention. Governor Edmund Randolph, reporting on the Constitutional Convention to the Virginia Ratifying Convention in 1788, Governor Randolph explained the following, quote, "With respect to a standing army, I believe there was not a member of the Federal Convention who did not feel indignation at such an institution," unquote. So Governor Randolph, who you'll remember was the person that greeted the delegates when they arrived at Philadelphia, and until they appointed Washington chair of the convention, Randolph was chair of the convention. And Randolph says that there was nobody there at the Philadelphia Constitutional Convention who didn't feel the fear and the danger of a standing army. On the other hand, Stevens says, the framers recognized the dangers inherent in relying on inadequately trained militia members as the primary means of providing for the common defense. Just because people had weapons, the amendment says well-regulated militia. In other words, you needed to have trained military. And so what Stevens is pointing out is that at the convention, there was also a fear of inadequately trained militia as the primary means of providing for the common defense. If we have to rely on militias that may be armed but they're not trained, we're going to lose. In order to respond to those twin concerns, fear of a standing army and the danger of having a militia that's not well trained, in order to respond to both of those concerns, a compromise was reached, says Stevens. Congress would be authorized to raise and support a national army and navy, and also to organize, arm, discipline, and provide for the calling forth of the militia. The president, at the same time, was empowered as the commander-in-chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States. This is the compromise. The central government, the president, is commander-in-chief of the state militias when it's federalized, when it's called into support of the whole nation. But with respect to the militia, Stevens says, a significant reservation was made to the states. Although Congress would have the power to call forth, organize, arm, and discipline the militia, as well as to govern such part of them as may be employed in the service of the United States, the states respectively would retain the right to appoint the officers and train the militia in accordance with the discipline prescribed by Congress. So the compromise the Constitutional Convention reached on this issue was to ensure that the states retained control over their own militias. They appointed the officers, they trained the militias. So if Congress did call the state militias into national service, they could rest assured, Congress could rest assured that the militias were well trained. While it empowered Congress to organize, arm, and discipline the militia, it did not prevent Congress from providing for the militia's disarmament. George Mason's concern was that the way the federal government could take power from the states is to disarm the militia. Mason, in the debates in Virginia on the ratifying convention, said the following: the militia may be here destroyed by that method which has been practiced in other parts of the world before. That is, by rendering them useless, by disarming them. Under various pretenses, Congress may neglect to provide for arming and disciplining the militia, and the state governments can't do it, for Congress has the exclusive right to arm them. So again, the evidence that Justice Stevens is providing here is suggesting that the whole attention on the issue of arms was related to the militias and the power of the militias. The conclusion then, the militias come first. That's the first clause in the Second Amendment, because that was the priority concern of the founders. The right to keep and bear arms, the right of the people to keep and bear arms, was principally for their service in the militia. And Stevens's implication here is that if you take the militia clause away from the Second Amendment, you totally change the meaning. And that's exactly what the majority did in the Heller case. By Scalia's decision to take the operative clause, the second one, and deal with it first, he essentially flip-flops 180 degrees the whole intent of the amendment. And again, the Supreme Court had ruled in Miller that that was the intent of the Second Amendment. And as Justice Stevens says, there's been no evidence presented to change that. None. Then he basically takes on the wording of the Second Amendment. And he looks at the Virginia Ratifying Convention. Of course, Madison was there, Randolph was there, George Mason. And this is what they did at the Virginia Ratifying Convention. They proposed the following amendments to the Constitution. In other words, the Ratifying Convention in '88 is to ratify the Constitution without a Bill of Rights. But as we know, halfway through the ratification process, most of the states began to recommend specific amendments they wanted added to the Constitution as a Bill of Rights. And here are the amendments proposed in Virginia. This one in particular, that the people have a right to keep and bear arms, that a well-regulated militia composed of the body of the people trained to arms is the proper natural and safe defense of a free state, that standing armies are dangerous to liberty and therefore ought to be avoided as far as the circumstances and protection of the community will admit, and that in all cases the military should be under strict subordination to and be governed by the civil power. And then there's also a conscientious objector recommendation that any person religiously scrupulous of bearing arms ought to be exempted upon payment of an equivalent to employ another to bear arms in his stead. In other words, even at the ratifying convention of the Constitution, Virginia is still putting the emphasis on the connection between militia service and the right to bear arms. New York proposed nearly identical language to Virginia during its ratification convention, that the people have a right to keep and bear arms, that a well-regulated militia, including the body of the people capable of bearing arms, is the proper, natural, and safe defense of a free state. And then Justice Stevens concludes this by saying, notably, each of these proposals used the phrase keep and bear arms, which was eventually adopted by Madison, and each proposal embedded the phrase within a group of principles that are distinctly military in meaning. Basically, then, it seems to me what Stevens has done, he goes on and includes quotations from New Hampshire's ratifying convention. Then he goes back and looks again at Pennsylvania and Massachusetts. And he points out that Madison, and this is my final blast here because we're 3 minutes from the end of our program. Madison, who was charged with the task of assembling the proposals for amendments sent by the ratifying states, was the principal draftsman of the Second Amendment. He had before him, or at the very least would have been aware of, all of these proposed formulations. In addition, Madison had been a member years earlier of the committee tasked with drafting the Virginia Declaration of Rights. That committee considered a proposal by Thomas Jefferson to include within the Virginia Declaration the following language: no freeman shall ever be debarred the use of arms within his own lands or tenements. The committee rejected Jefferson's proposal, and Madison was a member of that committee. Madison knew exactly what he wanted the Second Amendment to say. The issue was and continued to be from 76 all the way up through the ratification of the Constitution and the approval of the Bill of Rights. The main issue began to be the power of the state militias and the obligation of citizens to be armed in order to serve in them. And what Heller does is turn that reality on its head. I don't believe that Scalia's majority opinion would stand reconsideration. That's my own opinion. We are at the end of our day. It is 59 minutes after the hour, and I think we're pretty much done. There's one more quote that I want to share with you, and maybe we'll begin that tomorrow on this particular issue. So at the beginning of tomorrow's program, we'll go back and review some of this stuff, maybe for the first 15 or 20 minutes of the program, and then we'll kind of move on to other issues. Thank you so much. Be safe, watch the weather, and thank you.